Well, that certainly was some food for thought for the rest of the day. This first panel could really go on for the rest of the day, but it won't. I promise. What we're going to hear from now, and I think Michel Paradis will tell you more about it, is how to think about the challenges that are put before government when it comes to the weighing of security and liberty, the pendulum swing from security to liberty, what the challenges are legally, what the challenges are in the policy world, how they collide with one another, how they reinforce one another, and all of that in a very short amount of time. I'm going to introduce the moderator. It's Michel Paradis. I don't know if many of you know him. He's been at the center before. He's a senior research fellow at the center. He is currently writing a book on Japanese war crimes in World War II, which is coming out, I think, later this year or early next year?
Before Father's Day of next year.
Before Father's Day of next year. Okay, that's really good to know, Michel. Michel, you probably know from reading the newspaper, works for the Military Commission's Office as a senior defense attorney. He's argued some of the more high-profile constitutional issues before the courts about Guantanamo, about detainee issues, about individual detainees. And we have him here to talk about that on other occasions. Today, he is going to serve both as moderator and panelist, as are all our moderators, because they are all individuals who know these fields as well as the panelists they are sharing the podium with. But the most important thing about Michel is that he went to Fordham as an undergraduate. He went to Fordham for law school. And when I met him and decided he was just somebody who had to be part of this conversation of the center in a big way, I didn't even know he went to Fordham. So with that, Michel, it's yours.
Thank you very much, Karen. So it is my privilege to be moderating the panel today our first panel today, on Reconciling Liberty and Security in 2016. Now, as a starting point, I think it's important to remember that September 11th was 15 years ago, and it is difficult to think of another historical event, maybe perhaps other than the atomic bombing of Hiroshima and Nagasaki, whose basic implications we have struggled to understand and live with for such a long period of time. In 1960, we were not still debating what Pearl Harbor was about. In 1980, we were not still worrying about the implications of the Gulf of Tonkin. In 2005, we were not still wondering what kind of world we were going to live in as a result of the fall of the Berlin Wall. Yet here we are, nearly a generation later, deeply divided over what kind of world we want to live in as a result of the attacks on the World Trade Center and the Pentagon 15 years ago. So here with me to discuss and beginning on my right is Rachel Brand, a member of the Privacy and Civil Liberties Oversight Board. Previously, she was the Assistant Attorney General for Legal Policy and White House Counsel in the George W. Bush administration. David Cole is the George J. Mitchell Professor in Law and Public Policy at Georgetown. He's a regular contributor to the New York Review of Books, the legal affairs commentator for The Nation, and is the author most recently of Engines of Liberty, The Power of Citizen Activists to Make Constitutional Law. Jameel Jaffer is Deputy Legal Director of the National American Civil Liberties Union and Director of the ACLU's Center for Democracy. He's the author of a forthcoming book on the Obama administration's drone program, which will be published by the Free Press. Matthew Olsen is the co-founder and president of IronNet Security, and prior to rejoining private life, he worked for over 2 decades as a leading government official on national security, intelligence, and law enforcement issues, including most recently as the director of the National Counterterrorism Center, and before that as the general counsel of the National Security Administration. And then finally is Matthew Waxman, who is the Liviu Librescu Professor at Columbia Law School, and was previously the principal deputy director and acting director of the Secretary of State's policy planning staff, as well as the Deputy Assistant Secretary of Defense for Detainee Affairs. So we have an excellent panel this morning, and I was hoping we could perhaps start with a threshold question. As someone who led America's national security efforts for decades, what is national security?
So we didn't do a lot of prepping before this conference, before this panel.
We sent some emails around this morning, actually.
and it's a bit of hyperbole to say I led all the things that you said I led. I was the director of the National Counterterrorism Center for 3 years, from 2011 to 2014. But I was, like so many folks, people, I think all of us and others, 9/11, I think you rightly put, Michel, was a seminal event, not just obviously for our country, but for many of us from a career perspective. So I was a career prosecutor in a U.S. Attorney's Office in Washington, D.C. for 10 years when 9/11 happened. And so my career took a different turn because of the opportunity to work on national security issues from a legal perspective. So I worked on a number of issues, to answer your question, that really are best understood as national security legal issues that all sort of are part of the 9/11 set of laws. And I think, again, you're spot on, Michel, in talking about how what a catalyst 9/11 was from a legal perspective, because you have this developing area of the law that is really about counterterrorism. So to answer your question, from my perspective, national security law is largely the laws that have evolved since 9/11 based on, a whole body of law that forms the context of that. But the issues that we're going to be talking about, that you all are talking about for the rest of the day, and what we're going to talk about in this panel, all really came sort of post 9/11, and those are the ones that we're still struggling with.
So, Jameel, is national security law the law of 9/11? And is that what we mean by it today?
So, as Matt said, we didn't do a lot of prep for this panel. So I guess a couple things in response to all that. I mean, I think it's definitely true that we're still struggling with the meaning of 9/11 and the extent to which 9/11 should change the way that we think of civil liberties and change the way that we think of human rights. A lot of the debates we've had since 9/11 about interrogation or torture, about surveillance, about the drone program, I think are often, those debates are often characterized as debates about where to strike the balance between national security and civil liberties. I'm sure I know I'm not the first to say this today, and I know I won't be the last, but I don't think that striking the balance is the right frame through which to think of those questions. I think that in many different contexts, the measures we take to protect security don't have to compromise individual rights, and to the contrary, compromising individual rights very often has the effect of compromising security. I think that the debate playing out right now in the Apple cases is an example of that, where security is actually on both sides of the equation, right? The government says we need access to this information in order to keep us more secure, and Apple says if you give people access to this information, if we give you access to this information, we will make everybody less secure. I actually think that that's not unique to the Apple case. That situation where some security argument is on both sides of the equation is very, very common, much more common than people often appreciate. Now, that was all by way of stalling. So your question was about what is national security law?
Is national security law the law of 9/11? Like, would we be talking about 9/11? Or excuse me, national security if 9/11 didn't happen?
Yeah, well, I think yes and no. I mean, a lot of the law that we rely on in legal, in litigation over issues like the drone program or the limits of permissible interrogation, that law pre-exists 9/11, right? A lot of it was created right after World War II to protect human rights in the wake of some of the worst human rights abuses the world had witnessed. And when we bring these cases challenging government abuses carried out in the name of national security, we're often drawing on law that preexisted 9/11. Now that said, many, if not all, of the terms in that body of law have been redefined post 9/11. And often terms that we thought of as having been settled turn out not to be settled at all. The meaning of those terms turns out not to be settled at all. I've been thinking a lot about the drone program recently, and even terms like associated forces or imminent, which is imminent is the term that is sometimes used to describe the circumstances in which the government can use lethal force outside actual battlefields, only in response to imminent threats. So imminent has a kind of conventional meaning, but it turns out that meaning is now highly contested. And I think you see that all over the place. You saw it with the interrogation program, with the term torture, which people thought of as a settled term, the meaning of it having been settled long ago, but it turns out that it wasn't settled. So the law pre-exists 9/11, but the meaning of the operative terms has sometimes been sort of called into question in new ways.
So it's an interesting point you raise, because a lot of the new meanings of words have been redefined. We only find out that words have new meanings much later. We find out through the release of the OLC memos, or more OLC memos about the drone program later, or the release of the FISA court's opinions, which have certainly over the past 15 years come out years after they were written, and these terms were defined in perhaps what you would say was a new way. And is that, Rachel Brand, is that how do you deal with secret law? How do you deal with oversight and law that itself is secret, as the public civil liberties oversight?
Yeah, well, that's a really hard question and a really important question. Sorry, this mic is... The thing about intelligence programs that makes them different from every other aspect of government is that there is some irreducible minimum of secrecy that has to surround them. So in general, transparency is a bedrock value of our government. Transparency is what enables accountability. It's the way that the people ensure that they control the government, not the other way around. If you're talking about the EPA or regulatory agencies, you can have, with some really narrow exceptions, you should have transparency about pretty much everything they do. When it comes to intelligence, though, for obvious reasons, intelligence programs can't be effective if every aspect of them is public, right? And so how do you deal with that conundrum of having accountability where you have to have some secrecy? And the answer is oversight by people in the government who are can be privy to all the information, and then who can impose discipline. And I could sort of go, if you want me to, I could go into my thoughts about what makes oversight effective, which I've been thinking about a lot lately, because there's no shortage of proposals for more oversight. People love to add more layers of oversight on, and sometimes that's good, but more oversight isn't necessarily better oversight, because it could simply be redundant and a waste of resources. At some level, it can get to the point where it inappropriately impedes the effectiveness of the program in a way that you don't want. So when folks are proposing oversight, they need to step back and think about how it fits within the many, many, many oversight mechanisms that already exist in the government. And I think you have to, sort of 4 things I was thinking about this morning, attributes that you should have. One is you have to have both independent and internal oversight. So I'm a member of the P Club. We're an independent agency in the executive branch. You've probably never heard of us because we're only a couple of years old, but we are an executive branch, permanent agency, independent. And so the great thing about being a member of the P Club is I can come here. I don't have any talking points from anybody, because what I bring is my own judgment, right? I'm independent from the other members of my board, and I'm independent from the administration. So within classification constraints, I can say whatever I want about the government's national security programs. That's important for obvious reasons. But if you took all oversight out of the government, out of the agencies that are being overseen, you would make it less effective, because the downside of something like the P Club is we don't sit in the day-to-day flow of business in the agency. So most of the time, we don't know where the discrete opportunities for oversight are. So you've got to have oversight bodies, general counsels, inspectors general, privacy officers, compliance officers. You have to have all those things within the agency too. That's one thing. And then you have to have oversight by all 3 branches of government, recognizing that each branch of government has its own institutional competences and places where it's not competent, and also its areas of constitutional authority. So you've got to have executive oversight for the reasons I just said. You've got to have congressional oversight, which will never be as granular or as timely as executive oversight, but Congress is the mechanism by which, in a representative democracy, the people engages in oversight of the intelligence community. Congress is the body that should, if it does its job well, ensure that the balance that's struck. I know everyone loves to hate the word balance, and I understand why, but I'll just use it as a placeholder for now. Congress is how we ensure that the right balance between privacy and security is struck. They have big hammers. They've got funding hammer, and they've got a legislative hammer. And then you have judicial oversight. Again, I don't think that judicial involvement is the answer to every problem, and we probably have different views in this panel about that, but there are areas where, in FISA, for example, where the court does oversee intelligence programs. Then you have to have a mix of both legal and policy oversight. We have a lot of entities in the government that make sure that the government follows the rules. It's like legal or compliance oversight. You also have to have people who do policy oversight, who step back and say, should we do this? Even if we can, should we? And that's both from the perspective of privacy. So there are lots of privacy interests that are not protected by the Fourth Amendment, but there are things we might want the government to do, even if it doesn't have to comply with the Constitution. And then there's a risk management aspect to should we do it. Are we going to create diplomatic risk if we engage in surveillance of a foreign leader, for example? So you want to have that policy oversight too. And then the last thing is I think you need to have a mix between skepticism, healthy skepticism, but also commitment to the mission of the agency. So you need people who can say, look, just because you have always done it that way does not mean you should always do it that way. I don't have to take everything you say at face value. I'm going to be appropriately dubious in the first instance. But at the same time, I don't think it's the role of an oversight body to just kick the agency in the shins at every opportunity. The point is not to always be critical. It's to take an independent step back look at what's going on and try to help the agencies do their jobs better, which means not only being more aggressive or more effective, but staying within the constraints of law and the appropriate constraints of policy.
Matt Waxman, as one of the overseen when you were at offices like Detainee Affairs, how does oversight, like where are the opportunities when you're making a decision about X, Y, or Z, and if it's in Iraq, if it's Afghanistan or Guantanamo, where you as a decision maker at the policy level think to yourself, how will this be overseen? Mm-hmm. Is that part of the process?
So it definitely is part of the process, and I should say I worked on detention issues really for the middle part of the Bush administration, which was a critical time because it included the Abu Ghraib crisis. It included some reforms by Congress in the form of, for example, the Detainee Treatment Act. It included some major Supreme Court interventions like the Hamdi case, the Rasool cases in 2004, establishing certain procedural rights for detainees. And what that added up to was watching the what was then usually referred to as the Global War on Terror detention program move from being largely a sort of self-regulated or internally regulated only program to being one where all three branches were very, very deeply involved, where you also had intense media and investigative journalism scrutiny. You had scrutiny by international organizations like the ICRC, UN bodies, other international partners. So it was a time that went from I think the administration felt like it was a pretty closed system to being one that was actually scrutinized from a number of different angles. One of the things that it taught me was the importance of having some of these independent checks, and none of the checks of different branches of government are perfect. But one of the things that I certainly experienced was there's something very powerful about having to justify decisions to another branch of government or another actor who has not been directly involved in those decisions. Sometimes even just the process, I mean, even just the process of having to go up and brief, for example, congressional staff, and I'm not talking necessarily about big flashy hearings or even the direct threat of new legislation, but just having to go up and, for example, brief congressional staff members, that can have a powerful disciplining effect internally of needing to go back, check your work, making sure that you have a persuasive justification. A problem with a lack of oversight, or I wouldn't so much call it a lack of oversight, but relying entirely on internal executive branch oversight, is you can end up being, I think, sort of too persuaded by your own arguments. You hear them over and over and over again, and you can become overconfident that you've got it right. And sometimes that process of going and having to justify it before an external actor can have, like I said, a very powerful disciplining effect.
So how does that then work out in practice when the oversight itself is secret? And I wanted to quickly turn back to you because I think I'm going to try and get your expression right exactly, but in terms of pushing the bounds of the law and doing what the government can to prevent the next terrorist attack, I think one of the expressions you used was you want to get chalk on your cleats. And the idea being that you want to get as close to the line as possible without falling over it. But is there a problem when the runner not only can get chalk on his cleats, but is the one who we trust to throw the flag on the play? And when you're dealing with these internal agency deliberations, how much can we trust that those who are operating in secret know when to say, hey, we need to make sure we brief Congress on this. We need to make sure we take this to the FISC or the P-Club.
Right. So I can't take credit for the metaphor. This is really Mike Hayden, General Hayden, who came up with the chalk on the cleats metaphor. But it has proven very useful and very malleable, and it fits a lot of different of these scenarios. I think and I've used it in the past. But the basic idea from an operational perspective is, if you're the leader of an intelligence agency, or you have responsibility for the country's national security, and you are trying to decide where you want your operators to be, whether that's surveillance or collection of human information sources, if it's at the Department of Defense, you want to know that you're doing everything you can to protect the country. That means going up to, from an operational perspective, going up to the line that you're allowed to go to legally to make sure that you're doing everything you can. Because the line, if you're an operator, that line reflects from your perspective, the balance, where the right place that the country's allowed you to go, making sure that civil liberties and privacy are protected, but also that you have the room to operate. And I've used this metaphor in a way somewhat critically as the general counsel at the National Security Agency to say, look, I understand why the operators want to go up to the line, but I'm telling you, as the lawyer responsible, the line itself is somewhat of a misnomer, because it's not, as the lawyer, we know that line, to your point a bit, is not always 100% clear. It's certainly not a straight line. It tends to zigzag. It's dynamic. It's not static. It changes in response to Congress and the courts and changes in the law. So if the line were just a clear, bright, straight line, didn't change, it'd be a lot easier to be the lawyer, right? But that's not the case. And then you add in another element of who's the referee and who's deciding whether we're inside or outside the line. So I think, I would just sort of pick up on the points that Rachel and Matt made before about the role that oversight plays, because it's really, there are aspects, obviously, of national security law that are secret, and less so now than a few years ago, but it is the case that the oversight that's conducted is typically external to the executive branch decision makers who are trying to figure out where that line is. And to my mind, it began with me as a general counsel at NSA, but that was just the beginning of playing the role of referee, and there were multiple layers of oversight, including executive branch, Department of Justice, where I came from before going to NSA, but then extending to the places that Rachel talked about, and then beyond the government to the press, which is an important part of that oversight. So There's a lot of referees on the field, just to play the metaphor out a little bit further, throwing flags. Sometimes they throw the flag willy-nilly. Sometimes they throw it based on reasonable decisions, I think. But there's a lot of people out there making sure that even when things are done in secret or in a classified setting, that they're done appropriately.
Michel, could I?
Yeah.
I don't understand the sports analogy. I'm not even sure what sport you're talking about, but I think I understand the general concept of getting close to the line. But the one thing to keep in mind is that the fact that the line often isn't clear is a problem from many perspectives. One problem, you want to encourage compliance. Whatever the rule is, you want people to comply with it. And if you don't, because most people that are in the intelligence agencies are not Matt Waxman or Matt Olsen. They're not highly educated lawyers who have lived this, they're analysts, they're operators, they're people for whom you need clear rules. And so lack of a clear line, at least to compliance problems. It also, though, leads to sometimes overcautiousness, which I think gets more to the chalk and the cleats metaphor, if I understand it, because if you look at the 9/11 Commission's report about the lack of failure of information sharing about Hazmi and Minhar prior to 9/11, it wasn't really that the rule said you couldn't share. It's that the perception was that the rule said you couldn't share, and therefore people didn't share. So you got to be cognizant of that problem too.
Yeah.
Dave, yeah. Did you have something specific you wanted to say?
Yeah. So how do you turn this on? There you go. So I think Rachel and the two Matts have made a very good case for the importance of oversight and the importance of structuring oversight well. And I think we actually structure internal oversight pretty well. I think the Privacy Civil Liberties Oversight Board, on which Rachel sits, has done a tremendous job. It has the worst acronym in the United States, PCLOB, but other than that, it's been very good. But I think what has been missing and what makes the difference is oversight by the most important actor, and that is us, the public. And so, just a couple of examples, right? There was a tremendous amount of oversight of the NSA's phone metadata program, in which they were collecting all of our phone communications and keeping them for 5 years, regardless of whether there was any connection to terrorism. The Obama administration inherited it and kept it. Congress reenacted, which was briefed on the program in some of the ways that has been referred to, reenacted Section 215, which was the ostensible authority for the program, 7 times. The Foreign Intelligence Surveillance Court, which is the judicial branch which is supposed to provide oversight, approved the program something like 16 separate times without even writing an opinion as to why it was somehow authorized for the government to collect phone data on every single American citizen. When did that change? It changed when Edward Snowden disclosed to the world that the United States was doing this. And suddenly, all 3 branches of government changed their position. Obama appoints a special panel. They recommend a whole bunch of reforms, and he adopts a significant number of those reforms, none of which he adopted before the public was brought into it. The courts, a court in D.C. declared the program unconstitutional. A court in the Second Circuit, in a case litigated by Jameel and the ACLU, declared the program illegal as never authorized under Section 215. And the Foreign Intelligence Surveillance Court finally actually wrote an opinion trying to justify what it had authorized without even writing an opinion 17 times, 18 times previously. And Congress changed its tune and repealed the authority in the USA Freedom Act, but not until the public was brought into the matter. And it's not just the NSA program that reflects this pattern. The torture program, the CIA's torture program, authorized by a secret memo written by the Justice Department, once that memo was disclosed to the public, the Bush administration had to rescind it. They were fine with it as long as the public didn't know about it, but as soon as it became public, it was not supportable. The same thing with the black sites. The black sites, once they became disclosed, the CIA's secret prisons, in relatively short order, the Bush administration emptied them out. And I think that's because the most important oversight is us, and it is civil society in particular, and the press in addition. But those entities cannot do their work as long as the information is kept from us. And Rachel's absolutely right. Of course, a certain amount of intelligence has to be done without full publicity about the details. But I think one lesson we've certainly learned from the past 15 years is that a lot more is kept secret than is justified to be kept secret, and that a lot that is done in secret is unsustainable once the public is brought into the picture.
So on that, I want to push you on that a little bit. So I think Professor Cole's recent book, Engines of Liberty, is probably the best book on constitutional theory I've read. And that's not to deter you from reading it. It's actually a fantastically readable book. His case studies are brilliant. But it really gets to a certain insight about our Constitution being about the expectations of the people for what the law and what the Constitution is supposed to do. And you make a very good case for that. But when you're dealing with things like national security where, you said there is a premium to be put on secrecy, what is the standard? What standard should be applied? When should the public be informed? Because it's easy, because in certain respects, it is easy to say after the fact, yes, the torture program was clearly illegal and has caused as much damage as anything else to the credibility of the United States and the legal system. But we only know about that because we can look backwards. There are many programs that we don't know right now. And so what is the rule for government actors moving forward? How do they know it's time to extend the metaphor, to throw the flag?
That's a tremendous question, impossible to answer, because these judgments have to be made in a case-by-case way. This is why classification is such a wrenching problem in which pretty much everybody who's ever been involved in classified materials agrees that there is tremendous overclassification, and pretty much everybody who has ever looked at the issue agrees that there has to be some classification, and that you have to make these decisions on a case-by-case basis. But I think again, my sense is that what we have seen is a tremendous incentive on those who are inside to keep things inside and to keep the public out, and that's what we really need to fight against. And so things like disclosing the outlines of a program without disclosing the details of the program, the kinds of decisions that are made all the time when a document is released with redactions. In other words, you take the document and you say, how much of this can we disclose to the public and how much can't we? And inevitably, when government officials are challenged on those decisions, they release more. This is and Jameel knows this better than anybody, in Freedom of Information Act requests and litigation. Each step you take to push back against the government, lo and behold, more and more, they're able to disclose more and more of what they previously said couldn't possibly be disclosed without undermining national security. So we have to keep pressing. And I think what you need to do is build a culture on the inside that recognizes that it is important to push back against the inevitable tendency of those on the inside to keep these matters secret.
So on that, Jameel, because you have litigated both a number of the FOIA cases, so the disclosure, getting previously classified documents disclosed, but also the actual merits of a number of cases, like the 706 program or the drone program. And so I'm going to ask you the question as a lawyer you always hate hearing from the bench, but it's the same question I posed to Dave. What is the rule? Like what rule does, for example, the ACLU want to be in place, not only for the disclosure of things that are classified, but also things like the drone program? Is the ACLU's position the drone program is never constitutional?
Right. So, I agree with David, both that it's a really important question and that it's impossible to answer in the abstract. But I do think that there are general principles that, if maybe they're always true, and if they're not always true, they're pretty close to always true. And I think that one of those is that the public should know what the law is, and it should know what the law means. You may need to have secrecy about how the law is implemented. You may need to have secrecy about specific operations. But in a democracy, the public should know what the law is, and it should know what the law means. And it needs to know those things because in a democracy, these are first principles, right? But the law has legitimacy because it reflects democratic consent. And if the public doesn't know what the law is, it's not in a position to advocate for changes to the law. And you can't any longer say that the law reflects democratic consent. And if you think, more specifically of something like the drone memo. So in July of 2010, the Office of Legal Counsel wrote a memo justifying green-lighting the killing of an American citizen in Yemen on the theory that citizen presented a sufficient threat to national security that the government was justified in using lethal force without judicial process, without presenting evidence to a court. A quite remarkable decision being made by the executive branch behind closed doors. And there's a long, I can't remember how many pages it is, but maybe 30 pages, a 30-page legal memo that provides the administration's theory, the Office of Legal Counsel's theory, of why this, what other people might call an assassination, why this assassination is actually lawful. What is the justification? What was the justification for keeping that from the public after the strike had been carried out? I accept for the purpose of this discussion that there was some justification before, although even that, I think that's a question of redaction rather than categorical secrecy. But even if you accept that there was some justification for keeping the memo secret until the strike was carried out, what was the justification for keeping that memo secret after the strike was carried out? I can't think of one. And when we ultimately press back against the secrecy, we ultimately got to the Second Circuit here in New York, and the court ruled that the memo should be public. But that was 2014. So 4 years went by in which the public was in the dark about the government's rationale, the government's legal justification or purported legal justification for killing an American citizen without presenting evidence to a court. And I don't see the justification for that. And I think that if you look at the other programs, the other areas of the law that we've mentioned today, surveillance or interrogation, you see the same pattern where obviously there are things that the government has a legitimate interest in keeping secret, but what the government is actually keeping secret is far broader than that core that the government actually has a legitimate interest in keeping secret.
Actually, Matt, what is then answer Jameel's question? What is the rationale for keeping law secret, if that's what is being done?
So I don't know in this case actually what the rationale is, and let me say I come at this having both been a government official inside national security government departments and agencies, and now also as a law professor who teaches constitutional law and international law. And I think those two perspectives pull me in some different directions. I'm both very hawkish on the government's need to keep especially operational details, but also sometimes certain policy decisions very closely held secrets. But I also feel very strongly about certain principles that Jameel and David have talked about, including this, I think, a very, very, very strong, let's call it at least a presumption that law ought not be secret. There would have to be a very, very compelling justification for it not to be. And I also, based on my own experience, witnessed what I think is a big problem of overclassification inside the government. There are all kinds of sort of bureaucratic cultures and incentives that I think point generally in favor of more and more classification and not a lot of cultural factors, institutional factors, professional incentives pushing back in the other direction. I do hope that one of the lessons of the last 15 years is that even from a national security standpoint, secrecy and both sort of a natural tendency of the government to want to keep national security programs secret, a natural tendency of the executive branch often to want to push back against more oversight. That's a very, very risky strategy that often can come back and bite the government, because it means that you are isolated, alone in defending those programs. It means that when they do come to light, and I think one of the lessons is pretty much everything does these days. You don't have a lot of defenders. You don't have nearly as good a foundation as you might have if you had put in place stronger oversight, if you had gotten public support or congressional support in from at sort of the ground floor. I mean, David's example of the telephony metadata program is, I think, also a very interesting one, and it does point to, I think, a danger that one also has to worry about in designing oversight architecture, which is that we generally assume that more and more layers of oversight is good. But there can also be a bit of a buck passing tendency that can come if you layer on more and more oversight. There may be a tendency, for example, if you're inside the government, to say, well, if the Foreign Intelligence Surveillance Court said we're good to go on this, then then it's good. We've got a court saying it's fine. That's kind of what we need. We can pocket that, and we don't internally need to review it as carefully. So I think one needs to be. I just think one needs to be careful in and thoughtful in what the appropriate oversight architecture is. It's not necessarily. I think the formula is not necessarily sort of more layers equals good.
Rachel?
Yeah, I agree with most of what's been said here about the dynamic between transparency and secrecy, but I just caution that this is actually a lot harder than it sounds in practice. Yeah, there's overclassification, definitely. When I was at DOJ, I saw many documents, minimization procedures, for example. I thought, why is that classified? But I would caution, one practical motivator of overclassification and of just unwillingness to talk about things is having access to classified information is a real burden. I sometimes, my office is a SCIF, so I can have the classified documents in my desk, but I sometimes will keep the classified FISA court opinion in the desk and read the redacted version, because I don't want to have to try to remember when I come here and talk to you which parts are classified and which parts are unclassified. And it's a real thing, and for folks in the government, they are afraid of disclosing something that could be damaging to the national security. So there is a fear that motivates that dynamic. The other thing I would say is that it is often really hard to tell in a vacuum whether a particular piece of information, if disclosed, would be damaging to the national security. I have had briefings on the intelligence that enabled a particular operation, and you think, wow, I never would have thought that would have been the thing that would have enabled that. And it's not intuitive unless you sort of know the whole picture about something. So it makes those decisions about what is law that should be public as much as possible, and then where do you cross the line into the sources and methods that, if disclosed, will enable the bad guys to evade surveillance, right? That line is really hard to pinpoint.
Well, just very quickly, I want to sort of pick up on Rachel's point. I had a SCIF, a secure compartmented facility in my attic, which was Great for my son, my little son, who thought it was the coolest thing in the world to be able to go and show his friends this room in my attic, at least from the outside. But it also, to Rachel's point, was a huge burden, not only because I was expected to work 24 hours, but also because I had so much access to classified information that I think to sort of also pick up on your point, Rachel, I generally agree with Jameel and David's points. But this conference is hindsight, and it is easier to do this in hindsight than it is when you are responsible for carrying out these programs. Can you go further in disclosing more information? Does that serve fundamentally important principles? Absolutely. And I think to answer the question of where the line, how to answer the basic question of how to do this, I do think it's useful to think about what the legal rationale is as a line. If we should be able to disclose the legal rules without the operational details. And I will tell you this is not a new thing that we just thought of after Snowden. This conversation occurred as long as I've been in government. Did we always get it right? I think a lot of people think no, and I would agree. We didn't always get it right. That's the nature of decision making. But the conversation, can we disclose more? Can we say more about the legal rationale without undermining the operational effectiveness? That's a conversation that was occurring all the time, and not just within the executive branch, but in interaction with Congress and with the courts.
Well, so I want to pick up on that too. I also would be curious if you had your own email server in your skiff.
No, I did not.
But the question is, the courts actually that came up, and it's come up just a few times, but not very much in these. When we're thinking about oversight, because when we're talking about oversight, we're not just talking about a bureaucratic process where it's check boxes, because I agree, when it's viewed that way, it certainly does become an incentive to pass the buck. But when it comes to the courts, and we think of oversight from the courts, that is typically where we look to reconcile security and civil liberty, to take the title of our panel. And the courts have been, how have the courts been?
AWOL is the word you're looking for, right? So, no, I think that for the most part, it's true. The courts have been AWOL in these debates over liberty and security. Now, that may sound like a strange thing to say, because you can look around the country and you can see hundreds of cases involving national security and civil liberties, but in the vast majority of these challenges to programs of the kind we've talked about today, the cases get knocked out at the threshold on a procedural argument like the state secrets doctrine, or standing, or political question, or immunity, or Bivens special factors. There's a whole long list of arguments that the government can and does make to justify kicking these cases out at the threshold. And the result is that the courts have not actually weighed in on the lawfulness of a lot of the things that we've talked about today. The cases I referred to earlier were cases in which we challenged the lawfulness of targeting an American citizen without presenting evidence to a court. And when we brought that challenge before the strike had been carried out, the government successfully argued that the question of whether this American citizen could be targeted was a political question, committed to the political branches. The courts didn't have a role to play in deciding whether that person should be targeted or not. And then when we brought a similar case after the strike had been carried out, the government said, well, you know what? Even now, it may not be a political question, but special factors in the national security context mean that remedies that might be available to you in other contexts aren't available to you here. There's no remedy for an American who has been, or the estate of an American who has been targeted by his government. And that I think is quite an astonishing thing, that this administration of all administrations presided over the development of this rule, that the executive branch can unilaterally declare an American citizen to be an enemy of the state, and on the basis of that declaration, not reviewed by any court, carry out the killing of that American. I think that is an astonishing thing, and I know that there were a slew of newspaper articles about those cases when we brought them, but I still think that people haven't fully appreciated the significance of that claim that the Obama administration made. I worry that we will begin to appreciate it when the new president starts wielding the powers that the administration claimed.
So
Can I pile on?
Yeah, pile on.
So
Let me ask you a question because I think it's building off of that.
it won't change what I say, but go ahead.
No, that's perfect. because it's based on something Jameel said, which is, that Obama did it, right? This isn't so I don't know if anyone saw the panel, the conversation with Richard Clark this morning, but he described the Bush administration as, quote, war crimes on steroids, and then goes on to describe Obama as overcautious. And how much continuity is there between war crimes on steroids and Obama's overcautiousness? So yeah, and now give the answer you're going to give anyway.
Now you've tempted me to change my answer. So let me just say one word about courts. I think it's not always the case that courts are ineffective in responding to these kinds of concerns. I did a lot of national security, terrorism, civil liberties litigation before 9/11. On behalf of Muslims who were locked up on secret evidence, or the government was trying to deport on secret evidence, or the like. And we were actually quite successful before 9/11. And right after 9/11, I did a case with the ACLU challenging the closure of hundreds of secret of immigration proceedings after 9/11, in which there was no secret evidence whatsoever. Lee Gallant, who was a lawyer for the ACLU, was arguing this case before the Third Circuit in Philadelphia. And he gets up to make his argument, and one of the judges on the panel interrupts him and says, Mr. Gallant, before you start, I will never forget the morning that I saw the trade centers fall. How can I possibly rule for you? And I thought that was very candid on the part of this judge, who was basically abdicating his responsibility, at least openly. But that is, to me, that's a metaphor for the challenge, which is that in these moments, courts are, they're made up of humans as well, and so you can't rely entirely on them. But I would say, notwithstanding the fact that the courts didn't do a great job, the Supreme Court did rule against President Bush's claims of unilateral executive power on 4 separate occasions. And more significantly, if you talk about the war crimes on steroids at the outset, by the time the Bush administration left office, President Bush had released 500 of the Guantanamo detainees. He had suspended the CIA interrogation torture program. He had emptied out the CIA's black sites. He had suspended extraordinary rendition, in which we abducted people in foreign countries and delivered them to countries like Syria and Egypt so they could torture them for us, going even further than our own people would go. And he had put the NSA's warrantless wiretapping program, which he created unilaterally, under judicial supervision. Hadn't really restricted it much, but at least it was now under judicial supervision. None of that was ordered by a court. No court ordered any of those things to happen, and yet they all happened. So I think the interesting question is, why did they happen? How did they happen? That's what I address in my book, and the short answer is it is civil society working through a variety of forums involving advocacy here and abroad, using human rights tactics against the United States, the same kinds of tactics that human rights advocates use against countries that have no court system, international shaming and the like. And eventually Bush felt that he had to curtail most of these measures. There were people on the inside who felt that he should, but those voices were not heard in the first part of the administration. They were heard in the second part of the administration because of this pressure. So I don't think we can, put too much hope in the courts, but I do think we can put hope in the people if the people organize through effective organizations like the ACLU or Human Rights Watch or Human Rights First or the Center for Constitutional Rights and the like. You can make a significant difference. And I'm not one to say Obama is the same as Bush. I think there's been some continuity, but there's been significant change. But much of that change actually took place by the time the Bush administration left office, and not because Bush had a change of heart, or God knows Dick Cheney had a change of heart. You read their biographies, their memorials of this, and they have no doubt that anything they did was in any way a mistake, and yet that change happened.
Well, having been in the in the leadership through both administrations. Did we go from war crimes on steroids to being overcautious?
So I didn't see Dick Clark's comments. So I agree with Professor Cole. I mean, I was in the Justice Department during the transition from the Bush administration to the Obama administration. Much of what had happened, I thought that was a great recitation of some of the changes that had occurred in the second half of the Bush administration, from interrogation to detention to surveillance. I worked on the Guantanamo review under the Obama administration. I worked on the surveillance laws. I mean, much of what had happened at the end of the Bush administration then continued on into the Obama administration. And the other thing, I really agree that there was a lot of continuity there, which actually is a positive thing, something that we should strive to look forward to in the next change in administration, primarily from my perspective because it's really important operationally for the national security enterprise to have continuity. They are looking for rules to follow so that they can know what those rules are and be effective in staying on the right side of the line. So, look, I think the continuity was there and was very important.
Matt, continuity, was it important?
Yeah. No. I was just going to actually echo some of those points. I think the Obama administration is responsible for some significant reforms, but I think the period of greatest reform of our post-9/11 counterterrorism law and policy was the second half of the Bush administration. You saw much more change during the second 4 years of Bush than you saw between Bush and Obama. One of the important changes that I think President Obama did bring in was, as David said, the CIA enhanced interrogation program had already been suspended, and the Obama administration has made some important moves to basically institutionalize that, making it much more difficult to roll back, which is important if you look at where the politics of this issue are, right? I mean, it was just a couple of months ago in a Republican primary debate that the Republican candidates were asked, would you bring back waterboarding? Now, I mean, it's pretty, just to pause for a moment, it's pretty stunning that in a presidential debate, we would now have as a question, as sort of part of normal discourse, like what do you think about Common Core standards? What do you think about regulation of carbon emissions? What do you think about waterboarding? It's just a policy tool that's talked about, and the idea that you would even in a presidential debate go into a particular technique, right? Not just what do you think about aggressive interrogation, but what do you think about this particular technique? So I thought that was quite an interesting commentary on sort of the public salience of this. Also, though, interesting in my mind were the answers, which were quite diverse, actually, for even on the Republican side, in the sense that you had Donald Trump, if I'm recalling correctly, you had Donald Trump saying, of course I'd bring it back, and I'd bring back much worse than that. You had Ted Cruz with a kind of internally inconsistent mishmash of, I'm firmly against torture, I don't think waterboarding is torture, and if I'm president, I'll do whatever it takes to keep America safe. And then you had Jeb Bush, the brother of the president who had actually used it, saying, actually, I wouldn't bring it back. I think the law right now, which doesn't allow it, is good. So I don't know. I don't know whether to be optimistic or pessimistic, actually, based on kind of where that debate is. I am, though, quite hopeful that the Obama administration's reforms, on top of Bush administration reforms, make it very, very, very difficult to roll back to roll back changes on enhanced interrogation. On the other hand, and I would just say, compare that to another big reform push that President Obama talked about, which was on detention issues. And there, he's going to leave, I think, great uncertainty and great flexibility for where the next president wants to go. I mean, barring some, last-minute solution, which I don't see the political will, I haven't seen it demonstrated to push to get Guantanamo closure over the goal line, the next president actually has a lot of flexibility to design a detention policy going forward. And I would just point out, since we were talking about the role of courts, it was seen by many civil libertarians as a great thing when habeas corpus rights were extended to Guantanamo detainees. One result of that, and one result of the Obama administration's litigation of Guantanamo cases, is some pretty good law if you're the executive branch and want to engage in detention of future at least Al-Qaeda, possibly now also ISIS detainees without trial. You now have essentially all three branches up to the D.C. Circuit level saying the 2001 authorization of the use of military force includes broad detention authority to detain enemy fighters from Al-Qaeda and associated forces. That's a pretty powerful legal consensus if you want to use it as the next president of either party.
So Rachel, in thinking then, because we are talking about reconciling liberty and security in 2016, and 2016 is a presidential election year, and we're going to have a new president. And we probably know it's going to be one of four people, probably one of two. What is the future of that continuity? How much continuity do you think will come from the Obama administration to the future? Is this stage set for continuity? Have we reconciled liberty and security in a way that's going to persist now for decades to come, or are we in a moment when things might change, when there's going to be a radical reversal, or in one way or the other, towards liberty or security?
So I'm subject to the Hatch Act, so I cannot make any comment on the campaign whatsoever or any of the potential presidents that we might have next year. But I do think, it was interesting to me when my colleagues and I on the board met with President Obama a couple of times as we were doing our reviews of the Section 215 program and the Section 702 program. If you looked at what he had said during his campaign, and you looked at the orders that he signed on his first day in office, you might think one thing about his perspective. And then if you meet with him in the White House Situation Room inside his SCIF, and you hear him talk in a small group about how to deal with security issues and protect constitutional rights, it is clear that he bears the burden of office. He gets the presidential daily brief every morning, and he knows what the threats are. And I think that will affect anyone who is the next president, regardless of party. And I think in part that explains some of perhaps of the continuity that you might see across administrations. Now, like detention issues is not something I've ever had any involvement or expertise in, so I can't comment on that. But just when you're on the outside, even a typical U.S. senator, if they're not on the intelligence committees or perhaps Homeland or Judiciary, they're probably not going to be day in, day out getting the threat briefings. They probably can get them if they want to, but they wouldn't necessarily be getting them. But then you become president, and you're gonna get that. You're going to have a different perspective once you've taken office, I guess.
So where you stand is a function of where you sit?
Yeah, I mean, I think that a point that Rachel made, I think, is a really important one. I mean, we're talking about the nature of national security law and in the counterterrorism realm, and we've talked about the courts and oversight and advocacy groups. all of which have played a huge role, an important role, but really the single biggest driver of the shape of the law of the past 15 years and the shape of the law looking forward is the nature of the threat in some ways. And that's both that's a cautionary thing to say from my perspective, and I think from all of our perspectives. We have to be thoughtful about how we react and how resilient we are as a government and as a people to the next attack, whether it's on the nature of a San Bernardino style attack or in the United States, something on the scale of what we saw in Brussels or in Paris. And that's a really important point to remember in terms of how the law develops.
So on that note, please join me in thanking our panel.